and telling you some of the stories of some of the cases that you've heard tidbits about. The number isn't 600, it's closer to 1,000 cases have been filed in South Florida. And those cases have been filed by a group of about 4 or 5 associations represented by 3 or 4 different sets of attorneys. And what we have discovered is that those attorneys are using forms over and over and over again. And unless you handle a lot of these cases, such as I do, most of the lawyers that are handling the defense of these persons and businesses that are being sued haven't recognized what's been going on in a lot of the cases. And although I'm not alleging that every single attorney that I have opposed has done this, what I have seen is an attempt to charge for work that was not done. I represented the baseball dugout, which was one of the businesses that was sued that caused Mr. Foley or Congressman Foley to file this bill. Baseball dugout fixed the problems within a week or 2 of being served. The lawyer that sued this company came out there and said, yeah, everything's fine, I want some money. He thereafter sent my client a letter saying, I want $4,500. $4,500 to do about 2 hours worth of work. That case is settled. My client made a contribution to a charity of his choice. We paid $250 in fees, in costs, and I sent them packing. But I was only able to do that because I knew that some of the other cases that they had filed were mirror images of the other cases. The discovery that was filed, the interrogatories, the request for production were all the same. And what happens is you have small businesses that don't know any better that get hit with lawsuits like this, and before they know it, they're looking at a $4,000 or $5,000 attorney's fee. In South Florida, we have court procedures which mandate that certain things be done within 60 days, certain things be done within 90 days. Counsel must meet. Counsel must disclose witnesses. Every single business that I have represented in the past year in these cases, I have immediately said, fix it now and fight them later on the fees. And for that reason, I've been quite successful in having the cases against my clients resolved quickly. The problem is, when I have a client who's now faced with a $4,000 bill, how does that client justify paying me to go to the courts to fight? In federal court, litigants get attorney's fees for arguing attorney's fees. So if I'm successful in establishing that an attorney is not worth $500 an hour, $600 an hour, $1,000 an hour, he's still going to get something, and he is still going to get attorney's fees for having fought an unsuccessful fight. And for that reason, I attempted to help Congressman Foley in drafting this bill. I'm not certain that 90 days is appropriate. Perhaps now is the time to debate the issue of how you go about protecting people's rights that need assistance immediately, but at the same time, you protect the businesses. And let me tell you, it's not going to go away. I've been predicting for the past year that you're going to see an explosion of ADA litigation, and that's what's happening. It ain't going to take long for the folks of South Florida to realize that more and more attorneys are going to find out that it's a great way to make fees. And you've got law firms in South Florida that are making hundreds of thousands of dollars filing lawsuits that are mirror images of each other and settling the cases and getting $4,000, $5,000, $6,000, $30,000 at a crack. I support some type of protection for small businesses. I'm not certain if 90 days is the appropriate way to do it. I definitely feel that folks that need assistance and protection from the courts should get it. But at the same time, the businesses that are operating under the perception that because they have an occupational permit in which supposedly an expert in zoning and an expert in how buildings are supposed to be built has come to their shop or their business and said, you're approved. How do you tell somebody who calls you and says, I just got sued for ADA violations, shouldn't take you more than a couple of phone calls because I've got a certificate of occupancy, so obviously I'm in compliance. And then when I go and speak with them or I meet with them, I have to tell them that, well, no, you're not in compliance. The local inspectors were not aware of or did not inspect your business for ADA compliance. So I would urge you to discuss and debate what is being done here today. I'm not certain that 90 days of nothing is good, but at the same time, I know that 1,000 lawsuits this year, it's going to be 5,000 in a couple of years. You're going to have the federal courts clogged with these cases. And one last thing. One of the things I would suggest is some type of offer of judgment procedure by which, if a business is sued, that business can roll over, concede the problem, fix it, and yet not be hit with a huge attorney's fee. In Florida, we have offers of judgment and demands for judgment that allow businesses to roll over, or litigants that have been sued to roll over, concede that they were wrong, and offer to fix the problem. That's why under the state code, it's easy to handle claims for attorney's fees. You file the offer or the demand, and then you can take them before the judge and see if they get anything over what you've offered. Perhaps that type of procedure could be employed in assessing attorney's fees. But the way it is now, there's a lot of businesses that are getting hurt by a small number of individuals. And all of my clients, although they have fixed the problem, all of them have had to pay some sum of money that usually greatly exceeded the amount of effort and work that was in the case. Thank you.
Thank you, Mr. Fields. And I apologize to the other members of the panel, but we again have a series of votes. The good news is this is a series of 2 votes. So this should not keep us long. What we will do is recess the subcommittee now. We will reconvene at 1:30. So the subcommittee will reconvene at 1:30.